Good morning, everyone. Welcome to our second of 3 breakfast seminars that are highlighting current topical issues for clients throughout the Northeast region and across the country. As the world gets smaller, Foley has come to realize that many issues facing clients in one city are actually the same as many others, and we feel like this is a very good way to sort of highlight common issues for clients. Today's presentation, Litigation Avoidance Strategies, How to Reduce Legal Costs by Expanding Your Legal Team, applies to all companies who employ lawyers, and taking a more proactive approach to in daily business practices can reduce exposure to potential future litigations. We're pleased to have Erica Morbido as today's presenter. She has almost 15 years of experience as a litigator. She's also the co-chair of DC's litigation department and the vice chair of the firm's litigation department. Erica's here in DC, but the seminar is also being simulcast in New York and Boston and as a webinar for those located elsewhere. The Foley women attorneys of the Northeast region are responsible for this breakfast series. And without further ado, here's Erica.
Good morning, everyone. Thanks, Brittany. I appreciate y'all spending your morning with me. This is a very important topic. I think it does cross the borders and is relevant to not only attorneys, but particularly to officers and directors, as well as in-house counsel and out-house counsel. It's an extremely hot topic nowadays, I think, because we have the ever-changing landscape with litigation and what's being expected by our clients. So what I want to take you through today is not just litigation avoidance strategies and how to reduce the legal costs, but also really how to analyze a case when it comes to you. So why this becomes relevant is when a client calls you, or if you're an officer or director of a company, if you're in-house counsel and your business folks come to you, the first thing they want to talk to you about is, how do you solve my problem? And these can range anywhere from contracts with vendors, lease agreements, possible mergers, acquisitions, insurance contracts, compliance questions, fiduciary duty obligations, starting a business and winding down a business. And I'm sure you can all think of a whole host of other reasons and issues that come to us. And I think we have both an ethical duty and also a moral obligation to our clients that when we sit down to them and we're first presented with a problem, we don't have to just look what's right in front of our face in terms of solving the problem, but we have to look down the road a bit and figure out whether or not what we're doing is ultimately going to prevent them from being in litigation down the line. It's becoming more and more increasingly a hot topic for officers and directors of companies, as officers and directors are being dragged into litigation much more now than we've seen in the past. It's also something that our in-house counsel deal with on a regular basis, because their business folks come to them with particular contracts or issues or company concerns, and it's the in-house counsel's job to take a look at it and try to meet the expectations of what the business folks want, but also trying to make sure that there's a preventative measure in place such that if the contract gets executed, that there'll be minimal risk for litigation in the future. So why do we avoid litigation? First of all, of course, the obvious reason is costs. Whether you're in-house counsel and you're consulting with your client and your business folks, whether you're an officer or director, or whether you're outside counsel, the first thing you should be looking at is costs. Attorney's fees obviously are one part of the cost, and it's expensive, but it's really important that when you sit down and you talk to whoever your client is, or your company or your board, for example, that when you're deciding what course of action you're going to take, that you really take into consideration what's going to happen if you ultimately go down the path of litigation. And so in other words, you want to be proactive as opposed to reactive to try to avoid some sorts of costs. The other thing, of course, is risks. The old adage is that litigation is inherently uncertain. So even when you look at a contract, for example, or you're asked to assess an insurance contract, for example, you're an in-house company and you want to know whether or not your officers and directors are adequately covered from an insurance standpoint, a couple of the things you want to look at is if this comes to an issue and we get into litigation, what's the likelihood of success? Even if you think the likelihood of success is better than not that you'll prevail, litigation is inherently uncertain, and so there's always going to be a risk if you go down the path of litigation. The third thing, of course, is time, and that's something that I don't think our clients understand or appreciate enough. They're primarily focused on cost, but the other big thing is time. And the real expense is by, when you are involved in litigation, your employees, of course, and your officers and directors and the people that run the day-to-day operations of the company are taken away from their daily activities and are, thrown into the tranches of litigation, which in and of itself is a very not only time-consuming but cost expense for the company. You also have delay. We all know litigation can be drawn out. Even if you're successful in litigation at the onset, it doesn't mean that this case won't go on appeal. So not only will your costs continue to incur, but also the time aspect of it. And of course, you have the effect of litigation on other issues. And that's primarily the reputation of the company. You also have reporting requirements as a company for your auditors, in which case you have to disclose litigation. It can also affect your insurance liabilities and requirements. And so really when you're sitting down and you're looking at everything, your ultimate goal is to avoid litigation. One of the ways to avoid litigation is you really have to get real with your clients at the very beginning. And what I mean by that is when somebody comes to you and asks you to take a look at a contract or a lease agreement, or they tell you that they're possibly interested in a merger or an acquisition, or they're considering starting up a company or winding down a company, or whatever the actual legal issue is that they're bringing to you, you have to ask the hard questions up front. Because by failing to do so, you will find yourself in a reactive mode as opposed to, again, a proactive mode. And the hard questions, I just listed a couple of them on the slides, and that's, who, what, where, when, how, and why. You really need to understand what the deal is and what the ultimate goal of the deal is. You need to understand who the players are going to be involved in a particular deal. You need to understand the rationale behind the client, and you need to make sure that when you're asking these questions that you're getting to the real heart of whatever the issue is, so that, and we're going to go through this forward in the slides, so that you can institute your own practical advice and considerations that the client probably would not have thought of. Some of the things you have to do with your clients, of course, is advising them to use common sense. It's business partners can often be liable for each other's debts. That's just a simple example, and I gave some out on the screen. And so it makes sense to consider avoiding business partners about which you know little. That's true if you're presented with a contract. So for example, if your in-house counsel and your business folks come to you and they want the company to enter into a contract with a vendor, for example. One of the things that in-house counsel should be asking their business folks is, do we know these guys? What's their propensity for litigation? Should the in-house counsel be doing some due diligence on their own to find out who the other party is to the contract and whether or not that other party has ever been sued before, whether or not they've got a propensity for litigation, what their insolvency issues are if you're a service provider and you're seeking payment. It's not enough to just review a contract in a box and look at the terms and conditions. You really want to use common sense and make sure you understand all aspects of what's going into the contract and who the contracting parties are. The other thing is make sure you can prove it. Whenever you're talking about a deal and you have an eye towards litigation, again, when I say an eye towards litigation, it's really an eye towards hopefully trying to avoid litigation. Whether you're being consulted to put together, for example, a merger and acquisition, whether you're being asked to look at a contract, whatever the case may be, you want to make sure that if this does come to litigation, whether it's a month down the road, a year down the road, 5 years, 10 years, whatever the case may be, you want to make sure that at the very onset when you put the deal together that you have sufficient documentation that you're going to keep and that you're going to be able to have in order to present the case or defend the case to the extent that it does ultimately get litigated. This goes to the point about oral contracts. I mean, typically you will see in a contract a provision that states that if there had been any oral communications, that they're not binding and that the contents of the contract are contained in the four corners of the document. That sounds great from a practical standpoint, but the reality of the situation is that there is such a thing as parole evidence. And so if a court determines that a contract's ambiguous, despite your best efforts to not make it ambiguous, and despite the fact that you have a provision in there that says that no oral and any oral agreements are non-binding, to the extent there's a disagreement over one of the terms, for example, a court will allow parole evidence such as testimony as to what maybe the parties' intents were on a particular provision. So it's very important that when you're going through the process and steps, that you're making sure that you really understand what it is, what the client's intentions are, and that to the extent you have documentation to prove it, that you can. And that may even be notes from conversations, for example, with the other side through negotiations. Use precise words. Again, judges take words very literally. Almost every jurisdiction has a strict statutory interpretation of contracts. Courts are not there at the time that agreements, deals are negotiated. They're not there at the time that you have a conversation with your insurance provider, for example, about what type of coverage you're going to get. And so the courts look, of course, first to the contract or the document or the deal to figure out what it is that the party intended. So make sure that you're not just doing a cut and paste job from a previous deal, and that you're really taking into consideration specific facts of the deal and making sure that every single word has a meaning for being in the contract. And that's an important discussion that you can have with your clients. It's something as in-house counsel you should be talking about with your business folks. A lot of times business folks talk in generality, and it's the job of in-house counsel, and to the extent necessary to also seek outside counsel help, but to make sure that you really understand what the meaning is in a particular contract. Because if you don't understand what it is, you're going to have a very difficult time explaining to a court what that particular word means. So again, I mean, we're always saying don't reinvent the wheel by using sample documents or sample contracts or moving forward. But on the other hand, you have to make sure that when you are cutting and pasting a particular provision, that A, it's relevant to that transaction, and B, also that you really understand what the contents of that transaction are. The other thing is to teach your employees to care about your business. Satisfied employees who have an interest in their company's future work to keep customers happy and avoid disputes. Disgruntled employees, of course, are a source of liability for any company. That's particularly important, particularly if you're an officer or director of a company and you're talking to your staff. It's the people that handle the day-to-day exchanges with vendors, with clients, that ultimately end up getting you in trouble. Either they don't understand what the business is, they don't care about what the business is, and so they make representations and warranties, whether or not they have the power to make those, and whether or not those representations and warranties would ultimately be legally enforceable. You get into trouble when you have disgruntled people who really don't care about the company. So it's important to make sure you give adequate training to make sure that if you're in-house counsel and you're talking to your business folks, that they understand what it is that the deal is, and that they understand the information they're conveying to their customers. Learn to doubt. This is probably one of the most difficult things we have and we do as lawyers, and that is to doubt and to question what it is that your clients are asking you to do. And again, whether you're an officer or director, whether you're a general counsel, whether you're outside counsel, you have to ask difficult questions, and you have to doubt what it is when somebody comes to you with a deal. Because the old adage of if it looks too good to be true, it is, unfortunately, is oftentimes true. People have very good intentions when they go into business with each other, whether it's starting a business, whether it's entering into a merger and acquisition, whether it's entering into a contract. The idea is that we're doing this together because we're in a relationship and we hope that the relationship's going to be successful. Unfortunately, however, I guess fortunately if you're a litigator, that's not always the case. And so as a result of that, you want to ask the doubting questions from the very onset to make sure that the expectations of your client or your business folks or the person that you're representing in a particular transaction, that those expectations are managed and that they understand ultimately what the concerns are. Again, be careful what you promise. Do not make promises that you can't keep. One of the things we like to do as lawyers is to provide comfort to our clients, and also as officers and directors, you want to provide comfort to your employees. And the problem with that is that we sometimes overpromise and underdeliver, and ultimately that can get us in trouble and can get us into litigation. So be very careful about what you promise, because a deal's uncertain, people are uncertain, a court's uncertain, and litigation, of course, is absolutely inherently uncertain. One of the main topics that we wanted to talk about today and what we're seeing in the changing landscape of the practice of law is much more of lawyers with differing backgrounds working together from the very beginning of a deal. And the main reason that we're seeing this happen is because ultimately it does help avoid litigation. And what you should always remember is just because you can do it doesn't mean that you should do it. And what I mean by that is it used to be, not even that long ago, 5 years ago, 10 years ago and further back, it was very separate where business lawyers sort of did their deal and then litigators would get involved when there was a problem with a business transaction. And I can't tell you how many times, even in my practice, where I've had a business lawyer call me up or I'd have an in-house counsel call me up and say, look, we've been sued in this case, or there's been a breach by the other side in this case, and we're considering taking legal action. That's the first thing they say. And the second thing they say is, but we didn't prepare the underlying documents. And I understand they want to say that because they don't want me as a litigator to take a look at what the underlying document is that's now being litigated and go through it and say, well, why didn't you have this provision in there? Why did you put this provision? Or this is not a good provision for the forum in which we're in. And so as a litigator, when I'm presented with a contract after the fact that's now being litigated, I look at that and I think to myself, geez, had we been involved as a trial lawyer at the time that the contract was being negotiated or at the time that they were considering purchasing the assets of this, we could have structured this deal much differently, or we could have included different provisions in this particular contract that now at the time that we're litigating would have put us in a much more favorable position and really sort of give us an advantage and an edge. So one of the things we want to talk about today is to avoid litigation, you want to bring in the best people for the team at the front. And sometimes that means a little bit more cost. Sometimes that means you're not just a business lawyer thinking inside of a box and doing exactly what it is that your client asks us to do, which is put together a contract or get a M&A signed and executed. But instead, you're really bringing in a trial lawyer with expertise to be able to say to you, these particular provisions, for example, are something that you should include or should not include. Part of a trial lawyer's experience is revealing unforeseen consequences. And I'm harping a little bit on the word trial lawyer as opposed to just a litigator, because I do think that there's a distinction, and I don't think that it's a distinction without a difference. And what I mean by that is, while litigators certainly can provide a benefit to the business lawyers in the transaction, I think it's essential to really have a trial lawyer who practices in a jurisdiction to advise. And the reason for that is there's a lot of terminology in contracts that get taken for granted. And again, we're sort of trying to, on one hand, manage costs of a particular case. For example, when the client comes to you and they don't want to spend a lot of money, you want to be able to go to your box of form documents or go onto NetDocs and pull something off that you can basically use as a form. And that's fine. And I encourage you to do that because costs are certainly very expensive and something that we want to be conscious of when we're working with our clients. But on the other hand, You're going to see provisions in contracts that are going to be carried over from one contract to another. For example, arbitration provisions, mediation provisions, indemnification provisions, contribution provisions. Sometimes you see covenants not to compete. You see choice of law provisions. You see attorney's fee provisions. And the problem is even if a litigator understands what the technical terminology means, for example, arbitration or a mediation provision or an attorney's fees provision, what a trial lawyer may be able to explain better is that, yes, while an arbitration means X, Y, and Z, the reality of the situation is arbitration in this case for this particular contract is not something you would want, and here's why. Or if we do end up arbitrating it, we're going to be stuck in this particular jurisdiction, and this is not a good jurisdiction for you because of these reasons. Or you have a covenant not to compete, for example, in a particular jurisdiction. Now, a litigator may be able to say and remember, well, covenants not to compete need to be reasonable, for example, in geographic scope and limitations. But a trial lawyer who's had experience with litigating that particular non-compete in a particular jurisdiction is going to be able to take it the next step and say, not only is that one of the factors, but I have to tell you, in this particular court or in this particular jurisdiction, this is what the likely outcome is going to be. So you might want to tinker that. And choice of law, I mean, it sounds like a very easy thing. And oftentimes a company will say, well, look, I'm located in Arlington, Virginia, so I want my choice of law provision to be in Virginia, and I want the Eastern District to be the one to enforce it. Well, that may not necessarily be the case. What is the most important part of the contract? Is it a confidentiality provision that you want to be protected? What does the Eastern District of Virginia say about protecting confidentiality agreements? Is there an attorney's fee provision in there? Will that attorney's fee provision be enforceable in the Eastern District of Virginia? Sometimes a company has many choices of forums or choices of law in which they want to insert in a contract, and it may be different depending on who the other party to the contract is, for example, or it may be different just based on the subject matter or the real important term that is if the client has to sit down and say, what are the 5 most important things about this contract that I want to protect? You want to look at those and find out which forum, for example, is going to be the most advantageous. Same thing's true with indemnification provisions, for example. A litigator may understand that technically what an indemnification agreement means, but what a trial lawyer might say is, while that may be true in this particular jurisdiction, before this particular court, for example, this judge will not enforce an indemnification agreement unless the following language is included. Same things for contribution. I mean, there's a whole host of things, and I'm using these as just a couple examples, but there's a whole host of things that a trial lawyer can add at the very beginning of a deal that will really change and structure the deal. Most recently I was asked by one of our business lawyers to assist in a purchase of assets from a company that was tinkering on the line of insolvency. And one of the things the reasons that I was brought in was, if this person's going to purchase these assets, and let's assume they wind down the company, they purchase the assets, they believe they're taking the assets, for fair and market value. They had auditors come in and appraise the assets. The business lawyer believed they did their full due diligence to make sure that the transaction was going to be clean. Then I was brought in to say, is there anything else we should be doing? Because my client's concern is, they're an officer or director of this company, and they don't want to be accused later or be sued later for having sold something for under market value to the detriment of their creditors. And do they have any obligations that extend to the creditors? And when do those obligations extend to the creditors? And from the company's perspective, and now you may see that there's a division of interest between the officers and directors and the companies because of, for example, some sort of potential conflict. But the company also has to make sure, does it have a duty to its creditors? Is it making the right decision? Who should it pay with the proceeds of the assets that come in? Do they have to worry about potential fraudulent transfer or fraudulent transferee allegations if you have a disgruntled creditor, for example, who gets paid nothing once there's proceeds from the sale of potentially all of its assets? These are, this is just a very common practical thing where I sit down with the business lawyers and I say, this is the jurisdiction we should be in. This is why we should be in this jurisdiction. this is how you should structure the deal. These are some additional due diligence that you should do based on case law in this particular jurisdiction that'll be helpful if this transaction ever gets questioned, for example, later on down the line. And here's things that you want to do to make sure that this is an arm's length transaction. And then what we do together is we insert particular language into the contracts. We advise our clients of steps that they probably didn't think of, and probably that may or may not be necessary, but ultimately, if the case gets litigated in the future and there's a claim against either the company or the officers and directors, they're going to feel much more comfortable knowing that the risk has been mitigated because they went back at the very beginning and did a deal a little bit more different than they probably otherwise would have. And now, yes, there's an additional layer of cost there, but the cost that they avoided by either having to go through a litigation later on, and to the extent that there is litigation, they're probably going to be more likely to kick it out in a preliminary phase. They've probably saved a lot of money and time. Excuse me. On the flip side, business lawyers can help trial lawyers. Oftentimes, we do get cases, whether it's from outside counsel, where they've already got to the stage of litigation. And now I need to dissect the contract and figure out what we're going to do. Are we going to sue? What's going to be enforceable? How is it going to be enforceable? What forum are we going to select to sue? One of the things I do now as a litigator is, I don't always understand the business deal itself. I don't always understand, what some of the terminology might be. And I struggle with this sometimes, for example, with intellectual property and licensing provisions in a particular contract. So one of the things I do is I bring in the experts. Just because I think I can probably do it and I can prepare, it makes more sense to bring in somebody that understands this, that's put these kind of provisions and documents before. And I bring in the business lawyer and they provide guidance to me in terms of, here's one of the things that you should consider and something that, is a primary reason why we included or would include these particular provisions in an agreement. Oftentimes, you've got lawyers, for example, who have an expertise in non-competes. So rather than spend the time and figure out whether or not I'm going to be successful at bringing a piece of litigation and enforcing a non-compete and having a litigation associate, for example, do the research, I may call one of my business lawyers and say, hey, what are the chances? What's the law? What's the jurisdiction say on this particular case? Am I better off bringing it in a particular area? And chances are the business lawyer with that specific expertise in that area will be able to provide guidance. Sometimes you can change the rules. Within limits, businesses can negotiate the parameters of any future fight over their relationship. Again, this is another way in which trial lawyers can help you figure out ahead of time which elements of a dispute should be modified by way of agreement. And again, these talk about the statute of limitations, choice of law, venues, rights of waiver of jury trials. Companies assume, for example, that they want an arbitration provision because it's going to be less costly. That's not always the case. Companies want arbitration provisions sometimes because they believe that it's less public. Again, that's not always the case. It really depends on who the other party is that you're entering into a contract with. Sometimes these are people that work in your industry and you know that they're going to have a very low threshold for litigation, such as yourself, and maybe you then therefore want to eliminate the arbitration provision because it may be that by virtue of the fact that you can bring suit or be sued, that would in itself be an incentive enough for the two parties to be able to work out some sort of settlement resolution as opposed to arbitration. Again, trial lawyers or lawyers who actually have participated in arbitration and really understand the nuances between litigating a case in a courtroom versus an arbitration is going to be helpful. I have a client right now that has standard arbitration provisions in their contracts. And one of the issues that we're struggling with now is a claim was brought against our client in the arbitration forum before the AAA. And it's a lousy claim and it's weak, but for various reasons, we've sort of gone down the path of settlement because really it would be most advantageous for both clients for that to happen. The problem is you can't, once we're in this forum, we really can't get out of it for their failure to prosecute. And so what's been happening is, as a defendant in the case, we're not going to push the case. We're sort of letting the plaintiff continue to just drag its feet and do nothing, which is fine. We have to report it to our auditors, which is something companies don't typically like to do. But for the most part, as a defendant, we sort of just sit there and drag our feet. That's not a great outcome, but there's really no way we can force the issue of getting them out unless we continue to go through with the arbitration, which we don't want to do because we'd rather have this case get settled. If we were in court, however, and somebody files suit against you and they don't continue to prosecute the suit, the court, usually sua sponte, will dismiss the case on its own for failure to prosecute, or you as a defendant, of course, can get it out and it'll be knocked out. So that's just a very simple example of why any particular contract with a particular party in arbitration might not be preferable. Again, the important thing, though, is to contemplate the issues before a final agreement is reached. And that means sort of working with the people that are best in tune from a subject matter or an industry expertise, depending on what the contract's about. It means making sure from a expertise within the area of law, whether it's a business lawyer, whether it's a trial lawyer, that you're all getting together at the very beginning in order to try to avoid litigation down the line. Put your emotions aside. This is really important. A good attorney can offer suggestions on how preventive legal practices can be implemented without killing the deal. I think all too often we believe that we have to sort of show our client, and oftentimes with opposing counsel or with people on the other side of a deal or a transaction, that we can flex our muscles and that we're tough and that they should feel comfortable and confident in using us because we're going to win. But at the end of the day, that's not the ultimate goal. The ultimate goal for the client is to have a successful transaction. And a successful transaction means that you did your homework at the beginning, that you were proactive, that you did what you needed to do in order to best position the client or the deal from ultimately going towards litigation at the end. And sometimes that means that you can preserve things in a deal without killing a deal. And that's important. There's gives and takes in any transaction. There's risks in any transaction, and particularly when in-house counsel are working with their business lawyers, there's a very different agenda there. The business lawyers, for example, want the customer to sign the contract and they want to make money for the company. The in-house counsel lawyers want to make sure that these guys don't do anything reckless so that the company doesn't get sued at the end of the day. So you have different goals and different interests on one hand, but at the same hand, they're combined. Obviously, the business lawyers don't want the company to get sued either. And of course, the in-house counsel want to continue to have jobs by having a company, and they know that that's not going to happen unless the customers continue to sign up and enter into contracts. So it takes the time to sit down with your business people and to sort of find a happy medium. I mean, from a litigation standpoint and from a legal standpoint, our minds are trained to think we got to make this as airtight as possible so that we minimize, optimal minimization of future litigation. That's how we're trained to think as litigators when we're trying to protect our clients. The problem with that is if you do that, you've completely alienated your business folks, because your business folks are going to turn to you and say, that's great, I hear what you're saying, and probably if this contract were ever signed by anybody and we get sued, we're going to win. But at the end of the day, nobody's going to sign this contract anymore. So it's incumbent upon you as an in-house counsel, for example, or when you're being sought advice as outside counsel from your in-house counsel or from your general counsel, is to make sure that you sit down, because everything doesn't have to be airtight. You want to minimize risk. You want to find out where their propensity for risk is, but you also want to get the contract signed. And so if you have trial lawyers, if you have litigators, if you have business people, and you have the minds and the institutional knowledge of the client, you're working with the client to understand what their expectations are. If you put them all together, then you're going to not only have the best deal, you're all going to work together, and then you're also going to be able to later on down the line say you did everything you could to be able to minimize litigation exposure. So, takeaway points from this. Put the best team in place up front. Talk to your clients about this. Clients all of a sudden Understandably, when they see a bill and they see 5, 6, 7, 8, 9 timekeepers on it, they freak out. They don't understand. They assumed it was a very straightforward question. Don't just do this without having the client's input. Sit down with the client and talk to them. Explain to them what it is that you want to do, what it is that you want to accomplish, why you want to accomplish it, and why it is that you think you will be providing value to the client, for example, if you bring in an additional person. And let the client ultimately make the decision. It may be for a particular contract that, for example, has very low dollar amounts and they're not concerned so much about litigation down the line, that they may not want to add in an additional person. If it's a larger deal or a bigger transaction, at least you've done your job by advising them and guiding them and making suggestions as to why a certain person should be on a team. The other thing, don't reinvent the wheel if you don't need to, but reinvent the wheel when necessary. I can't emphasize that enough. We get too comfortable with cookie cutter forms. As a litigator and a trial lawyer, I can't tell you how many times I've heard counsel before judges when the judge asks a specific question about a contract and why a particular language or a provision was in a contract, and the lawyer says, well, Your Honor, we've been using these contracts for 10 years, 12 years, 13 years, whatever the case may be. Judges don't want to hear it. It's not an excuse. Quite frankly, I think it's malpractice. The law is changing all the time. That's why we have continuing legal education classes. Something could have changed in the circuit or in a particular jurisdiction minutes before you put the deal together. You need to make sure you understand what the most up-to-date thing is. So not only is a provision relevant, but the provision's relevant for this deal based on these facts, and that the information that you're requesting or including in any deal is still relevant in that particular jurisdiction for which you're including a choice of law forum. So it is good to use forms. It's good to make sure that you have the general concepts included, but make sure that you're doing your due diligence and homework by making sure that it's timely. Again, Benjamin Franklin, an ounce of prevention is worth a pound of cure. If you walk away with anything in terms of litigation avoidance techniques, it's this. Be proactive. Don't be reactive. Not only will your clients thank you for it, but they will also continue to go to you in the future. Clients don't want yes lawyers that just agree to whatever it is that they're asking. We have a duty, an ethical responsibility, a professional responsibility to make sure that we advise them. We are advisors. And I think general counsel have that same duty when they're talking with their business folks. And I think that officers and directors have that responsibility when they're talking with their clients. And while it may be a little bit more costly on the outset, if it can prevent litigation and all the negative implications of litigation that we talked about at the beginning, then it's worth every penny. I appreciate each of you coming today and listening in. I don't know if we have the capability for me to be able to answer any questions, but if anybody has any questions about anything that's been discussed today or would like a copy of the PowerPoint slides that were handed out, please certainly give me a call, send me an email. I'm happy to talk to anybody about it. I'm happy to provide any information if you have a deal or would like information about who might be a good person to be put on any of your cases. Again, thank you all for joining me this morning. I appreciate it, and have a great afternoon.